esteemed persons in the dais, the various office bearers of the ABA Organizing Committee, Ms. Pratibha Jain, dear friends in the audience, I've been asked to address you on future of legal education, glocalization of legal profession. So before I begin to reimagine legal education in India, let me try and address this August gathering in portmanteau form. Portmanteau, I discovered after this conference, in the context of this conference, is, of course, a blending of at least two words in keeping with your glocalization mega theme of this conference. So my guess estimate, that is guess plus estimate, is that this metaverse, that is meta and universe, attended by this impressive collection of brainiacs, that is brain and maniacs, under the auspices of ABA, is destined with its impeccable planning and diverse sub-themes to be a Bollywood, Bombay plus Hollywood, hit in the legal education ecosystem. This is my first detailed encounter with portmanteau forms of titles for seminars. Friends, reimagination of legal education in the Indian, but also in the global context, can be fruitful, infectious, delectable, and delicious. Legal education and law schools are the bedrock, the foundation whose quality, workmanship, and solidity determines the beauty, the longevity, and the functional utility of the superstructure of law. President Radhakrishnan's lament 50 plus years ago, he said, our colleges of law do not hold a place of high esteem either at home or abroad, nor has law become an area of profound scholarship and enlightened research. Unfortunately, though lesser, but unfortunately even today, has substantial resonance. A small number of dynamic and outstanding law schools still remain islands of excellence amidst a sea of institutionalized mediocrity. A few general points. A lawyer has to be a balance wheel, a harmonizer, a reconciler, more than simply a skilled legal mechanic. He must also be a legal architect, an engineer, a builder, indeed an inventor. That's a lot of things to expect from a lawyer, but good law schools are supposed to do all that. Our contributions must therefore focus not only on GNP, but also on GNM, gross national mind. The character of law schools determines the character of the bar and the bench, the two wheels of the chariot of justice. We must avoid time wastage in reinventing this wheel and focus only on tying up the vast existing corpus of rich data on legal education available already into a simple, uniform, national legal education plan and concentrate on its implementation in a consistent, continuous, and coherent manner. India's failure has always been the gap between promise and implementation. Democratization of law schools and of legal education is vital. While there is need to create more islands of excellence and eminence, like the institutions of eminence, for example, there is far greater need to uplift the average standard of the struggling, anonymous 1,500-odd law schools. We have to spread, therefore, distributive equity over inclusive legal education and minimize what has always been the bane of India, the many Indias within one syndrome. Substantively, our legal curricula must be made multidisciplinary, creative, and flexible. Global best practices adapted to local needs and nuances should be our guiding pole star in this glocalization endeavor. Antithetically, our curricula are actually, in most cases, rigid, stereotyped, and pedantic. There is an urgent need to integrate topics like reforms in justice delivery system. Very few courses in very few places still in 2023 have that. into alternate dispute resolution, practitioners' workshops, legal writing, clinical legal education, and so on and so forth. Sadly, teaching methods have also hardly evolved after the case study methods of the 1970s. A typical Indian law student may have about 9 to 10 optional subjects to choose from, whereas at a leading US law school, he'll be able to choose from amongst 200 to 300 offerings. Of course, as a slight aside, it is heartening to see more and more law schools across India building into their components reciprocal foreign interactions with foreign established universities. Whether in a semester, whether in an exchange program, whether in a visit, different models are on. There is absolutely no doubt, and each one of us who has had the privilege of studying abroad in any form for any duration, and I very fondly recollect my Cambridge years in this regard, there is absolutely no doubt that an approach to problem solving, which you learn with this global methodology, holds very valid and gives you a new insight in your local problem solving. So, how you approach a problem, how you solve domestic problems, in a sense, the foundations are frequently laid in the degree of globalization of your legal education when you were a student. Secondly, friends, there is a very serious problem of law teachers, or rather the lack of them. A vexed problem of numbers, of quality, of diversity, and of depth. Former Chief Justice Anand called law teachers, quote, largely marginalized, demoralized, unrecognized, and unrewarded, unquote. Law teaching can attract brilliant young minds only by shortening the substantial and unbridgeable financial gap between the leaders of the bar and the teachers. Reciprocally, those under special remunerative schemes have to be bound by valid legal instruments, bonds with appropriate legalese, to teach for a minimum duration without straying into greener pastures. A pilot program must create an alternative remunerative scheme, not hidebound by the present shackles of bureaucracy, and bureaucracy includes everything from UGC downwards, with more public-private partnerships, greater autonomy, and special financial terms. In all of this, global paradigms waiting to be adopted stare us in the face. Thirdly, friends, our law libraries are too few and woefully stocked. Latest technological tools of research must link each law school with the best sources of knowledge globally. A library cess levied only on senior advocates across the country must be operationalized for law libraries for maximum ground impact, and in particular for ground impact in urban India and rural India. Here again, of course, urban, you have another portmanteau example. Fourthly, some students, especially with contacts, unfortunately in India, have the luxury of plenty, while several of their more talented but less resourceful colleagues go a-begging. There is no objective evaluation system by the chamber head. What you need is an organized, computerized national plan for placement, allocation, internship, and training. As seniors in chambers, we find that there's a jungle raj out there, there's chaos, and I'm sure a lot of you applicants find the same. Fifthly, a national scheme must ensure that senior practitioners with expertise in particular areas compulsorily take a minimum number of classes in lesser endowed law schools, which should be part of the student's evaluation, namely that particular course or class. The legal education sector, the bar, the bench, the corporate legal sector, and the law firms, unfortunately in India, continue to function in silos of isolated splendor. The exact opposite, close, continuous, coordinated alignment in legal education is the need of the hour. Again, local and global best practices are available but remain largely unadopted. Our national law schools shone because of broadly three important innovations. academic autonomy by making it a standalone university. That's true in most cases, not all. Entrance through a strictly merit-based admission system based on a written test. And thirdly, an integrated professional 5-year law program with curricula innovation. Why we don't do this, these three basic building blocks of excellence, even partially in several other law schools in India, whether 3-year ones or 5-year ones, to me it remains an enduring mystery. There is, friends, a 2009, that's 13 odd years or 14 odd years old, resolution that all law schools should establish a legal aid center to provide inexpensive and efficient advice to needy sections of society, with final year students imbibing training at such legal clinics and benefiting from client interaction. Unfortunately, this also has been observed mostly in the breach. And you can't be misled by institutions of eminence or institutions of excellence which remain islands. Ninthly, the impact of stratification of colleges, of law colleges, has to be remedied if you want to reimagine legal education in this country. Central universities set up by Parliament have their law faculty as the university's law school. The problem arises at state level universities, which become affiliating bodies for private law colleges. There is here an institutionalized mediocrity and dilution of academic standards, in particular in the affiliated colleges category. Many do not have adequate and qualified faculty or law libraries, e-resources, and even no regular conduct of classes and examinations. One statistic tells it all. 3 Western UP state universities alone, 3 state universities in Western Europe, Meerut, Agra, and Kanpur, have affiliated 214 law colleges. And they offer almost 25,000 seats in LLB alone. I'm giving you a microcosm of one part of India, one part of a state. How can you expect high quality standards or an appropriate academic ecosystem? Linked to this, of course, is the imperative need to axe, to render extinct, to eliminate, to exclude. What? To exclude many, many, many existing law colleges. Madras High Court, a judicial body, as far back as 6 years ago in 2017, said that 85% of law colleges need to be closed. This is not my figure, I was astonished to read it. The irony, of course, is most interesting. After the Madras High Court said that 85% should be closed in 2017, the number has jumped from 800 in 2000 to 1500 in 2019. We are somewhere around 15 to 1700 now. Not 15,000, sorry, 1500 to 1700. Of these, in my opinion, and as I said, as Palkhiwala used to say, words to lead to some reform have to be an assault on the mind. So don't mind my bluntness, but if some reform has to happen, there must be some assault on the brain of those who have the policy powers. Closure of at least 500 of these 1,500, if not 750, dubious and substandard profit shops is urgent and imperative. These are mechanically churning out 1 lakh lawyers, that's 100,000 lawyers. The speed and scale in which we are producing law graduates is poorly matched with the quality of education, training, capacity building, opportunities that are available for law graduates. And here, a fundamental reimagination of this ecosystem is needed. At last count, unfortunately, no Indian law school, barring 2, found place in the top 300 law schools in the QS rankings. Global winds of ruthless competition must animate this area. More than Darwin, only the fully fit should survive in this ruthless global competition, or glocal competition, as per your title. All NLUs combined impart legal education to only 2,500 students per year. Now, these are the islands of excellence, which we are proud of. But look at the numbers they touch, the lives they touch. All the NLUs combined give 2,500 students per year, which is about 2% of the total LLB students admitted annually. 98% in terms of quality, availability, capacity building, opportunity is the big question mark. Our starry-eyed view of 5-year courses, which are very good, very desirable, and have become the fashionable buzzword for the last 2 decades, must not omit to strengthen the 3-year program. On par with the JD or the Juris Doctor program of American and Canadian law schools, so popular, so good, I would say, the Indian LLB 3-year program must be made more rigorous and full-time. And those who don't have it, even the NLUs, some of them should consider starting it, because there is nothing wrong or evil in a student wanting a 3-year broad-based education followed by a 3-year law program. There is a unique aspect of legal education in USA, which in my young years I've been very impressed with. Deep and pervasive engagement between law firms, corporations, non-governmental organizations, legal aid centers, think tanks, government agencies, intergovernmental organizations. I just mentioned silos in splendid isolation, ivory towers in splendid isolation. The exact opposite is happening here in India. This interaction, let alone collaboration with these 6 or 7 sectors I have just mentioned, is superficial, if at all existent. Last, friends, the elephant in the room must be addressed. And it's a big elephant and a powerful element. Only foolish persons like me might fear to tread where angels might fear to tread. The elephant in the room is the Bar Council. The Bar Council has too many functions. It's powerful not only because it's statutory, but it has just far too many functions. Law reform, disciplining lawyers, setting standards for legal education, and the vicissitudes of electoral politics, sometimes too purple and too vicious, willy-nilly, will necessarily compromise some degree of the discharge of these multifarious and diverse functions. You can see that I am using words carefully and cautiously, and also words of studied moderation at least. But I am still trying to speak the truth. So friends, I have earlier said, stuck out my neck, and I have no hesitation sticking out my neck again today. Either an empowered, broad-based, separate committee of academicians, chief justices, eminent lawyers should be set up, or an independent and autonomous National Council for Legal Education and Research, even if generally created by BCI, but independent and autonomous from the BCI, is necessary to bring the needed objectivity and purity in the legal education arena. Friends, as I end, all I can do is to remind you of some stirring words about capturing in legal education the promise and the premise reflected by thinkers like H.G. Wells, who many, many moons ago said, human history, more than anything else, is a race between education and catastrophe. Aristotle, even earlier, put it nicely when he said education is an ornament in propriety and a refuge in adversity. What India needs is a new electric fire to stir up fresh vigor in our legal education veins. Roadblocks and pessimisms should only remind us of Tagore's Akla Chalo, and more importantly of Gandhi's description of 5 stages of reform, something which is very well known but frequently forgotten. Gandhi said all such reform initiatives go through these 5 stages. First, indifference. Second, ridicule. Third, abuse. Fourth, repression. And 5th, respect. So don't be deterred. So long as we move in the right direction, success is bound to be ours. Thank you very much.